All right, let's talk about one of the most high-stakes games you've probably never seen up close, jury selection. This isn't just a formality. It's a strategic battlefield where a case can be won or lost before a single piece of evidence is ever presented. So how are juries really picked? If you're picturing someone just pulling 12 random names out of a hat, well, you might want to think again. The reality is this incredibly calculated game, a mix of psychology, strategy, and of course, the law. So yeah, let's pull back the curtain and see how it all actually works. Here's what we're going to cover. We'll start with the game itself. Then we'll look at the first big move lawyers can make, shuffling the deck. After that, we'll get into the quest for bias, how the final cuts are made, and, what happens when jurors go rogue. Finally, we'll talk about why this whole messy process is so important. Okay, let's get into it. This whole process has this kind of formal, fancy-sounding name. You've definitely heard it on TV shows. But what is it really? It's called voir dire. It's French, and it literally means to speak the truth. And really, that's the whole point, right? To get a big room full of strangers to be honest, to speak their truth about their lives, their beliefs, and, yeah, their biases, all in the hope of finding a truly fair and impartial jury. So, before a lawyer even opens their mouth to ask a single question, they have this really powerful first move they can make. It's a strategic tool that can completely change the game right from the start. It's called the jury shuffle, and honestly, the best way to think about it is like a card game. Right before the dealer starts handing out cards, you can ask them to shuffle the deck one more time. The point isn't to get a specific card, right? It's to change the random order. Same idea here. It rearranges the seating order, and that can totally change who's in the strike zone. That's the first group of people the lawyers are really focused on. Now here's the thing. The rules for this are super strict. A lawyer has to ask for the shuffle at this very specific moment, after everyone is seated, but before the questioning starts. If you miss that window, too bad. You're out of luck, and you only get one shot per case. That makes it a huge, high-stakes decision right at the top of the trial. Okay, so the panel is set. Now we get to the real heart of the matter, the interrogation. This is where the lawyers turn into part detective, part psychologist. They're trying to dig in and find those hidden biases, those life experiences that could secretly tip the scales one way or another. And this brings up a really fascinating legal idea called rehabilitation. So you'd think, right, if a juror admits they're biased, like they say, I really don't trust big corporations, in a case against a big corporation, that they'd be gone, automatic disqualification. But not so fast. A judge can actually try to rehabilitate them. They'll ask something like, look, I hear what you're saying, but can you promise to put those feelings aside and judge this case only on the evidence you hear in court? If that person says yes and the judge believes them, they can stay. It's all about where you end up, not where you start. And you see just how messy and human this all is in moments like this. In one trial, a potential juror was really wrestling with the idea of innocent until proven guilty. They just couldn't get their head around it and finally asked the lawyer, why can't we have maybe? It's such a simple question, but it gets right to the heart of the problem, doesn't it? Lawyers need a yes or a no, but human feelings are often just maybe. Okay, so after all that questioning, it's time to make the final cuts. Lawyers basically have two tools in their toolbox to remove people from the panel. The first one is called a challenge for cause. This is pretty straightforward. The lawyer has to prove to the judge, hey, this person is clearly biased. They cannot be fair. If the judge is convinced, that juror is gone, and you can make as many of these challenges as you need. But the second one, that's the peremptory strike. This is where it gets really strategic. Each side only gets a handful of these, and they can use them to bounce a juror for, well, pretty much any reason they want, or even no reason at all. It could just be a gut feeling. Now, I said almost any reason, and that almost is doing a lot of work. There is one huge, non-negotiable exception thanks to the Constitution. You are absolutely not allowed to use one of these strikes to remove a juror just because of their race. And this all comes from a landmark Supreme Court case called Batson v. Kentucky. So how do you prove something like that? Well, it's basically a three-step process. First, the party that thinks there's discrimination has to point to a pattern. They have to make a basic case. Then, the ball is in the other court. The lawyer who made the strike has to give a clear, race-neutral reason for it. And finally, the judge plays referee. They have to decide if that reason is legit or if it's just a cover story for discrimination. And this is where numbers can tell a powerful story. In a Batson challenge, statistics can be your smoking gun. Just look at this example from a real case. The lawyers used their strikes to remove 83% of the black members of the jury pool. But for non-black members, only 5.5%. When you see a gap that massive, it's pretty hard to argue that race had nothing to do with it. So you've done it. You've navigated this whole minefield and picked your jury. The trial can begin. But what if someone lied during questioning? What if a juror goes rogue and breaks the rules? Well, that's when things can get really messy, and it shows just how fragile this whole system can be. Take this case study, for example. There was a juror, a guy named Lamb, in a lawsuit over a defect in a Ford truck. During selection, he was asked all sorts of questions, but he conveniently forgot to mention one little detail. He owned a very similar Ford truck himself. Then, in the middle of the trial, he gets a close look at a key piece of evidence, and the plaintiff's lawyers see him just sit back in his chair, put his pen down, and stop taking notes. He looked like he'd already made up his mind. By hiding that key fact, he basically poisoned the whole trial from the inside. And if you think that's wild, it can get even stranger. Here's another story that shows how one person can throw everything into chaos. In another case, the jury is deliberating. Out of nowhere, the presiding juror sends a note to the judge. It asks, "What's the maximum amount of money we can award?" Well, you can imagine the panic. Both sides assume a huge verdict is coming, so they rush to settle the case right then and there. But here's the twist. It turns out the presiding juror sent that note all by herself. The other jurors had no idea and didn't agree with it at all. And this is where it gets really chilling. According to the other jurors, that same morning, the presiding juror walked into the room, cool as a cucumber, and just announced, "This will be settled today." That weird confidence, plus the rogue note, it raised some really serious red flags. Was she talking to someone on the outside? Was she being influenced? We may never know for sure. So we've seen the strategy, the mind games, the loopholes, and the straight-up mayhem that can happen. What's the final verdict on this whole process? Look, at the end of the day, the hunt for a truly impartial jury is, well, it's messy. It's complicated. It's deeply human. It's a game of strategy that depends entirely on strangers being honest about who they are. And yeah, it's flawed, but it's also the fundamental bedrock of our entire justice system. Which leaves us with one big final question to think about. After everything we've talked about, the biases we all have, the games lawyers play, the potential for things to go wrong, can a jury ever be truly impartial? Is that even possible? It's a tough question, and it's one that gets to the very core of what justice means.